Our justice correspondent Candace Kelley is here now to discuss all of this. Good morning to you, Candace. Yesterday, we heard William Brayn's voice for the first time. It was stunning. First time inside the courtroom, if you will. He was answering questions under oath about his conditions behind bars. Tell us the purpose of that. I know how it sat with me and perhaps so many others, but why was that done and why was it allowed?
Well, listen, his attorney was essentially saying, Sharon, that he was suffering conditions that were unacceptable. You know, the Eighth Amendment says that one that is behind bars should not be behind bars, suffering cruel and unusual punishment. So he was having him remark upon his high blood pressure, the conditions in the jail. Very strangely enough, Sharon, I think that we probably feel the same way. Very strange to hear him talk about how far his remote control was from where he was and the size of his TV when we're talking about someone who died. But still, nonetheless, this is something that attorneys do in order to make sure that their clients are not being treated poorly in jail. Another thing that he talked about was the speediness of this trial as guaranteed by the Sixth Amendment. I think what was interesting was that his attorney brought up a case, Shepard v. Maxwell. Actually, The Fugitive, the movie, was based upon this case. It was overturned by the Supreme Court, a murder case, because of the overarching media coverage. And he brought this up saying that this was a similar case, that this overarching media coverage did not guarantee him a fair trial, and that because of COVID, it was a long trial, not a speedy trial as guaranteed by the Sixth Amendment. Of course, the judge didn't have much to say in terms of any of this, saying that this is something that happened because of COVID, and he's going to address other concerns later, but that's why we heard from William Brayn.
Three men on trial fighting for their lives now, their freedom. They could go away forever. They fought every point, their attorneys did, including Ahmaud's sneakers, Candace. The point of contention, they were. Prosecutors wanted to use them to show that he was an avid runner. He was out for a run. But that could open the door to Ahmaud Arbery's past. Do I have it correct?
Absolutely. See, these sneakers were a point of contention because, as you said, the prosecution wanted to enter them into evidence to prove that Ahmaud Arbery was indeed an avid runner, as opposed to this person who was doing this willy-nilly kind of walking around the neighborhood on various occasions for seemingly no reason, even though he was dressed in running shorts and dressed in what we would perceive as a running shirt. The prosecutor said, let's enter these into evidence. The sneakers, they're worn down. It shows that he runs quite a bit. Well, the defense came back and said, if you're going to enter those sneakers, then we're also going to talk about other ways that they could have been worn down. They wanted to bring in his history, his arrest record, having stolen a television from Walmart, bringing a gun to a school. These are things that Ahmaud Arbery on record did plead guilty to. So the prosecution backed off. They said, that's okay with these shoes. We certainly don't want to open up that door because his arrest record, his mental health has nothing to do with what went on that fateful day, Sharon.
Yeah, that Sunday jog. The motions, Attorney Kevin Goff from Mr. Brayn was at it again with the black, he said the word black again, Candace, he did. The judge again, he files this other motion, the judge again says, no. It's not about intimidation. We're not doing that. He even at one point, I thought I heard him accuse the judge of calling the attorney, Mr. Goff, reprehensible. And the judge said, no, I didn't call you reprehensible, but the Colonel Sanders and the black, all of that, your comments were reprehensible. So did the judge do the right thing, or does this again, Candace, clear the way down the line for an appeal?
Listen, both are right. We can check both boxes there. The judge did the right thing, and that these motions are created to just be interruptive. That's what he's doing here. But down the line, this is why he's bringing them up. The attorney, he's bringing up these particular issues because they have to go on record if he's going to make it an issue down the line. But guess what, Sharon? It's on record. I'm not sure why he keeps on going after the same points of information to put on record when it is on record. But here's one thing, and I was talking to Dre Clark about this, and he's on the ground there, as we know, in Georgia. You know, what if he's doing this in a more kind of schematic way than we would imagine? Is he smarter than we think in that he's piling on all of these motions to bring extra media attention so that he can use that later for an appeal? I don't know, but there seems to be something behind this more than just the motions, because his motions are on record. And at this point, quite frankly, he's being redundant in court and wasting time.
Yeah, well, maybe the judge is smarter than him, because the judge may have an answer for that. Before we move on to Rittenhouse, the judge said, you're the one who's causing all of this, okay? But for your statements, people wouldn't be getting the caravan ready to come to Brunswick. Let's move to Rittenhouse, though. The trial, the jury deliberated about 8 hours, I believe, 8.5 maybe before they went home. What does it tell us, if anything, about what we can expect there?
Listen, with the Rittenhouse trial right now, as you said, 8.5 hours, the fact that they broke and did not maybe stay a couple of more hours led me to believe that they still have a long way to go, especially when they asked for jury instructions again, as well as the charges, because what's key here, as we know, is self-defense and provocation. That's all on the line. And the fact that they asked for that information so far only means to me that they're really trying to figure out exactly what these charges mean, and how to go about assessing them. But definitely they are not at the end of their journey, because again, if they had just maybe an hour left, they would have done it last night. They're going to continue today with those deliberations, Sharon.
About 30 seconds left. I know that this idea that Kyle Rittenhouse was provoked and not the aggressor, that's a central theme to the case. But I want to focus in, and I don't know if we have that video, okay, of him picking the jurors. I mean, many would feel with this judge, Kyle Rittenhouse has already won the lottery, Candace, but to reach his hand into this, why does the clerk bring it to him? Is this normal?
Yeah, listen, this is something that oddly enough is normal in this judge's courtroom. The same way as we talked about, he doesn't want anybody to be called victims. It's something that he does. He said that this wasn't going to be an aberration from this. And so as we saw, like some type of weird lottery, we saw him pick the jurors out of this tumbler in order to come up with the 12 that would be deciding his fate. He looked like he was playing a game. I mean, he looks like a young person. So to see him do this just looked very, very strange, but not strange, Sharon, actually, for this court.
Well, this court, I mean, Donald Trump's comb-over was normal in his house, Candace, but, you know, we'll see what else goes down here. I know you're going to stay with us. We need you more now than ever. Thank you, Candace. We appreciate it. We'll see you in a little bit.